Philip Jr. was an attorney at the U.S. Securities and Exchange Commission, or the SEC, in the 1990s. He knew what penny stock scams were, and he knew what pump and dump scams were. He worked to prevent those kind of scams from happening for 15 years, becoming an expert in securities fraud. He worked through the ranks at the SEC from staff lawyer to supervising lawyer to branch chief trial counsel and then senior trial counsel. He would go after those that committed security frauds, including people who committed penny stock scams and pump and dump scams. Penny stock is a high risk security that is available for a low price, hence penny, and they also have low trading volume. This makes them pretty volatile and open to scams. Penny stocks can sound like a good way to enter the stock market without a lot of money, but most penny stocks have an average negative annual return of about 24%. More than 90% of penny stocks fail. Penny stock scams involve short selling the stocks and then making sure that the value of the stocks fall, usually by spreading false and damaging rumors about the company. So the investors who are stuck with the penny stock loses while the short sellers make money. It's fraud because of the way the stock's price is manipulated with a false rumor campaign. Pump and dump scam works in reverse. The bad actors buy up stocks at low prices and then promote them without disclosing their interest and often telling bold exaggerations or outright lies to pump up their value. They then sell the stock at the inflated price to unknowing investors, the dump. When it turns out that the pump was false, the stock prices fall, often plummet, and the investors lose their money. After working for the SEC for 15 years, Ophel, like many others before him, would go into private practice. His firm loved him at first. His biggest client, Halliburton, one of the biggest companies in the world, loved him at first. He was a respected lawyer, an expert at first. But things would start getting weird there. There was $1 million or more in unpaid legal fees from Ophel's clients due to the firm. There were large sums of money moving into and out of the firm trust accounts for Ophel's clients. Clients sued and settled for nearly $5 million when Ophel got his company involved in a penny stock scam. He wasn't hired to do penny stocks, transactional work. He was hired, the senior partner would say, to do SEC work, helping public companies avoid the pitfalls and defending them when they were being investigated. They went to him and said, "Hey, we don't think this is working. What do you suggest?" So Ophel would leave and start his own firm. More on that later, though. Before we get there, we need to look at the lawsuits and bar complaints that began to pile up on Ophel. On March 13, 2008, the Grievance Committee of the Texas State Bar would find that Ophel committed a number of offenses during this time at his firm. The decision is no longer available as the Texas State Bar does not keep discipline decisions past 10 years. However, the summary goes like this. The Grievance Committee found that Ophel refused to return client documents to them after he was no longer the client's attorney. The client asked for them, Ophel refused. He also had a penchant for hiding or destroying documents. In one case, in a suit involving both his firm and himself by a former client, and in another case where he was being sued by a client. He did it again when he learned that a third client was planning to sue him. Lawyers just can't refuse to return client documents, and they also cannot just destroy documents that might be used to prove their wrongdoing. Lawyers also have to disclose any conflicts of interest that they have. For example, if they have a financial interest in a company that a client is suing, or if they have a relationship with one person that might be detrimental or contrary in interest to a client, they have to disclose that. These things have to be disclosed so that the people dealing with that lawyer can decide whether or not to continue as things are, or get another lawyer, or even ask a court to have the lawyer recused from a case. It's never the lawyer's decision to waive a conflict for other people. Their responsibility is to disclose it. The Texas Bar found that there were several incidents in which Ophel just didn't disclose conflicts. They also found that he lied to a federal judge in Florida, that he lied in court documents that he filed in a lawsuit, and that he plain refused to answer discovery requests. Now, discovery requests are a way that lawyers exchange information when they're involved in a lawsuit. They cannot be ignored. Finally, he would give clients advice and then deliberately not make any record of the advice he gave. This makes it hard for clients to argue over advice, complain that advice was wrong or outright illegal, or sue over faulty advice. It also helps Ophel hide what he was really doing, especially when it involved duping his own clients. His law license would be suspended for 3 years, and then followed up with probated suspension for 2 years. He was ordered to pay $70,000 in fees and another $17,200 in expenses. He filed an appeal in that decision, but it was dismissed for want of prosecution, meaning that Ophel never pursued it. In 2014, he would also be disbarred by the Oklahoma Supreme Court, revoking his law license there. Meanwhile, Ophel and 8 others would get themselves involved in a pump and dump scheme. Most of the transactions took place in 2004 and took 3 years of investigation after an SEC suit before trials happened. There would be nearly 24,000 investors who were ripped off in their schemes. Their scheme started out looking legit. Ophel and another securities lawyer, David Stalker, created some corporations. Now, this is really easy to do in most jurisdictions for a fee of about $100 and some simple certificates of incorporation. Then they obtained some stock certificates from a financial printer and issued those stocks to themselves. Okay, well, that is the normal course of business so far. Now, though, they have to find buyers. They needed investors and the help of a broker-dealer to sell the stocks. In order to make the pump and dump work, they needed good stories. So they made some up. Their corporations, which did not really exist except on paper, were at the leading edge of the best modern technologies. All of the investors in these fake corporations were going to make millions in the tech market. Rich beyond their wildest dreams, they believed. Ophel, Stalker, and their cohorts worked together to blast emails and create fake news releases to drive up the value of the stocks, even though they knew the companies had little to no value. I mean, what's a couple pieces of paper worth? 5 cents? 6? All they needed was for people to believe, and some 24,000 did believe. They would buy the phony stocks and the phony stories. There was also AVL Global's penny stocks that Stalker and Ophel, along with Peter Fisher and his son Tyler Fisher, dumped into the market to have unsuspecting investors purchase, without ever telling them that the company was failing and worthless. All told, there were 18 small, overvalued companies involved in the scam, including one called Emerging Holdings, run by one of the conspirators from literally his parents' basement in Reston, Texas. All of the stocks were sold in the OTC market, which means that they were not listed on stock exchanges, and the sales were never reported to the SEC. In a scene straight out of the movies, the federal investigators would have a convicted market manipulator help them in a sting. Stephen Lusko. Now, Lusko would approach Ophel in 2006 and ask for his help in creating a company to pump and then dump. Conversations, taped of course, would follow. Emails handed over would follow. Ophel would leave his law firm to start his own during the sting. He would be recorded saying he wanted to provide vertical treatment from beginning to end to make sure that what we build is defensible if anybody ever asks a question about it. He was ready to take his pump and dump schemes into the world of a full-time empire. Instead, it would all come crashing down. His 8 co-conspirators were convicted before him. Most of them struck plea bargains with prosecutors. He would be convicted in 2010 for his participation in the multi-million-dollar pump and dump scheme. He would end up in prison for 8 years to be followed by 3 years of probation. He had to forfeit $4,838,000 and pay restitution of a little more than $30,000. He would be barred from ever working in the securities industry again. Ophel's sentence was one of the harshest among the 9 total conspirators. But prosecutor Ed Power would say that the tougher sentence was deserved because Ophel lied in testimony and because he was a respected attorney and used that position to help provide cover for the fraud. The judge who sentenced him would say, "Your testimony was an affront to justice. It was one of the biggest pack of lies I've ever heard." He would appeal his conviction and his sentence, but the Court of Appeals, First Circuit, would deny his appeal. Once his appeal was finished, the State Bar of Texas would disbar him. He didn't even appear at the disbarment hearing or make any submissions in that case. He was still on that supervised release order from his 2010 conviction in January 2022. He just couldn't stay away from temptation. Both the SEC and federal authorities would charge Ophel again on January 19th. What did he do this time? Well, Ophel would conspire together with Justin Wallace Herman, who had once been a licensed stockbroker, to misappropriate millions of shares of a mining company called Mansfield Martin Exploration Mining, Inc., using forged documents and sham transactions. The mining company had mining claims in Arizona and Idaho. Ophel, going by the name of Jim Jimerson, really had a friendship going with the controlling shareholder of the mining company. He held himself out as a paralegal, though he was a disbarred felon, and began working in an office with the shareholder. He used the alias for a variety of reasons, but mostly so that those he was defrauding and authorities would not easily discover who he was and his history. After all, he had only just been released from prison. The person who issued stocks, broker-dealers, and transfer agents had an obligation to check on the identity of people they're dealing with, so he could not risk using his real name. It was vital to his scheme that none of these people find out his true identity. The shareholder held a debt note with his company. This isn't unusual that a large shareholder lends money to the company for startup costs, capital costs, and the like. That note said that on demand, the shareholder would get a little more than $867,000 back in shares worth 10 for a penny. 10 for a penny. Ophel was working with a private company named Armada that had mining claims in Arizona and Idaho. The company wanted to access public capital markets. Ophel was assisting them in finding potential transactions, including potentially having Armada purchase the shareholder stocks in the mining company. He would also help the shareholder onshore some of his own stocks, moving them from an offshore broker to an onshore transfer agent. He deceived the mining company into converting the shareholder's debt note into about 1.5 million shares by giving them documents that were fraudulent. Made it seem the shareholder had approved that deal even though he had not. Then when he was helping with the onshoring of stock, he duped the transfer agent into transferring the stock to Herman, again by handing over falsified documents that made it seem the transfer was legitimate. Then they manipulated the price of the stocks and dumped those shares on the investors. The total ripped off of investors was $1.3 million. Ophel would pocket $386,000, while Herman pocketed $935,000. Ophel and conspirator Herman would be sued by the SEC and also charged criminally with conspiracy to commit wire fraud. They entered guilty pleas, and Ophel would be sentenced on July 12, 2023. Herman, like Ophel, wasn't new to securities frauds. He had been convicted in October 2021 on several counts from a different penny stock scheme in Wyoming. He was awaiting sentencing on that when he was arrested for his scheme with Ophel. On January 21st, 2023, Herman was sentenced to 38 months prison to be followed by 3 years of supervised probation with almost $1.4 million in forfeiture. There you have it. Thanks for listening. If you're enjoying these videos and you want to see more, please click the subscribe button and hit those notifications so that you don't miss any uploads. We appreciate you. Thanks.